Okay, thank you very much. Well, I trust everybody's had a very good lunch. There's one thing I've learned to expect from visiting Hong Kong is always to be fed well, and today's been no exception. We've got 3 presentations in the next session. I will introduce the speakers very briefly because you've got their biographical notes in your pack, so I don't need to say very much more about them. Just to introduce myself, I'm Pete Mills. I'm the director of the PhD Foundation in Cambridge, and it's been a real pleasure and a privilege to have been involved from an early stage in the conceptualization of this meeting with Professor Leung and his colleagues. And we enormously value the relationship with CeBIL and the Academy of Medicine and other colleagues in Hong Kong. So for this session, we're going to dive a little bit deeper into European governance and North American governance of AI. And we're going to start with Professor Tom Goffin, who is Associate Professor of Health Law at Ghent University in Belgium. So Tom, please.
Thank you. Good day to you all. My apologies for not being able to attend live with you in Hong Kong, but I had to teach in Ghent as well, so therefore it was not possible for me to arrange my agendas in such a way that I could join you live. But thank you very much for the organization to still be able to present to you today. So my name is Tom Goffin. I'm a professor in health law at Ghent University, and I'm part of Metamedica. Metamedica is actually an interdisciplinary and interfaculty research platform at Ghent University that focuses from a digital and legal and ethical point of view on the new innovations such as AI in healthcare. My presentation today will not be on the AI Act of the European Union. It will be on another document that was recently developed within Europe, being the AI Convention of the Council of Europe. And so I will explore this AI convention and also look at how it matches with the healthcare situation within Europe. Just to make it clear, the Council of Europe is not the same as the European Union. The Council of Europe was actually created in 1949 as a response to the Second World War. And its main goal was actually to focus on human rights, to focus on democracy, to focus on the rule of law, and to protect really this human rights, democracy, and rule of law from an international perspective. And from that point of view, it was crucial, of course, that this institution could also make some kind of legally binding documents. And one of them is the well-known European Convention on Human Rights, and who says the European Convention on Human Rights in Europe also says the European Court of Human Rights, an institution that within the Council of Europe creates case law on human rights, and that really can hold contracting countries to the European Convention responsible if they infringe or if some institutions within their country infringe human rights in general. As you can see, currently there are 46 members of the Council of Europe, but this does not mean that since they are all 46 members of the Council of Europe, that they are also contracting party to each convention. Each convention that is created by the European Council of Europe is free for the member states to be signed and ratified or not. So each convention has to be looked at it from a separate point of view. When we look at the competency of the Council of Europe when it comes to healthcare, actually the Council of Europe has already done quite a lot of things when it comes to healthcare, such as the European Convention on Human Rights and Biomedicine already in 1997. This European Convention on Human Rights and Biomedicine is what is called in Europe really the Patient Rights Convention, since it collects and puts forward different traditional basic patient rights, such as the right to informed consent, the right to act according to the professional standards, right to medical file, right to complain, such things. So a really important document when it comes to protecting patient rights within the European framework. As you can see, 27 members of the Council of Europe have ratified this convention, and 7 members have signed but did not ratify, so it's somewhere in between. So it's quite a huge and important convention when it comes to protecting human rights within healthcare in Europe. And it's still called one of the only international legally binding instruments in protecting human rights in the biomedical fields. Also to be marked is that it's a framework convention, meaning that it's still much open for the member states to decide how to implement really these human rights, these patient rights, and the other protections of human rights within the field of biomedicine. Besides this, of course, the Council of Europe is also taking up other initiatives. This is actually their current things or projects that they are working on. And as you can see, besides artificial intelligence, a lot of things that are pretty much linked to healthcare, such as children participation in decision making, also in the field of healthcare. Equitable access to vaccines, treatments, equipment, certainly important when it comes to AI in health. Equitable and timely access to innovative treatments and technologies in healthcare systems, mental health care, youth forums, strategic action plan, all these things all come together to some extent with regard to the fact that they are linked to healthcare somehow. So therefore, when we talk about the initiatives taken by the Council of Europe and also within the field of AI, it's always linked also to these other domains in which the Council of Europe is very active. So the question then, of course, is, was there really a need to create an AI convention within the Council of Europe? And the answer to it is both yes and no. First, the no. No, there's not really a need for a new convention, since when we look at the competencies of the European Court of Human Rights linked to this broad European Convention of Human Rights, we can conclude that also this European Court of Human Rights could or should or can already rule on human rights issues concerning new technologies, also within the healthcare domain. And if we look at the case law of the European Court of Human Rights, we see that indeed this European Court of Human Rights has already taken a lot of initiatives when it comes to protecting human rights and patient rights specifically in the domain of healthcare. So it could already be possible that the European Court of Human Rights, when some kind of AI applications in the field of healthcare would infringe some kind of human rights of a person, like the right to privacy or the right to informed consent, of right not being informed sufficiently, that this could lead to a case before the European Court of Human Rights. So no, but also yes. Why is there a need for an AI convention? Since it was felt that there was a need to design more specific provisions to apply the existing Council of Europe standards on human rights to this AI-specific context. There are a lot of difficulties in interpretation of how these current human rights that are mainly focused on humans should be applied in the context of artificial intelligence. There was a need to legally embed these essential principles also in the field of AI, and also to set some standards, norms, certainly when it comes to supporting trade and the AI link that is made to that. So if we then look at this AI convention, it has quite a broad field of application, actually. It governs both public authorities and private actors. So it really comes down to pretty much everything that you can link AI to. But just to explore it a bit more, when it comes to the private actors, the private sector, member states who will become a contracting party to this convention will still be able to opt or for a direct obligation of the provisions of the convention to these private actors, or to decide really to take other measures to comply with the treaty provisions while fully respecting their international obligations. So they can still decide, the member states, the contracting parties to the convention, how they really will implement all these principles concerning AI and human rights within their own domain. The field of application is extremely broad, but not covering really everything. A couple of things are left out, such as the protection of national security interests, That being said, countries will still have to ensure that although national security interests are not covered, such activities do respect international law, democratic institutions and processes. Which is really left out is the national defense matters and research and development activities as well. But with regard to this last one, especially within the healthcare domain, there's a huge expectation, exception matter, when the testing of the AI systems may have the potential to interfere with human rights. You can imagine if you develop an AI-driven application for the healthcare domain, and there might be a chance that it infringes some kind of patient rights, that this, of course, will also cause problems for the AI application for the protection of human rights. So therefore, if that's the case, then of course this ex, exception is not applicable, and research and development activities will become a part of this framework convention. If you look at the definition of AI within this AI convention, it's mentioned that it's about a machine-based system that for explicit or implicit objectives infers from the input it receives how to generate outputs such as the predictions, content, recommendations, or decisions that may influence physical or virtual environments, and broad description, different artificial intelligence systems vary in their level of autonomy and adaptiveness after deployment. As you perhaps already have heard some kind of other presentations on AI, or will still hear today, this definition slightly differs from the one from the AI Act. But what is actually more important when it comes to this AI convention is not really the definition of AI, but the fact that the aim of the convention is to ensure activities within the entire life cycle of artificial intelligence systems. So the convention really focuses on these principles to be guaranteed in the entire life cycle of artificial intelligence, no matter where in the life cycle it is and no matter who it applies to. So it's extremely broad, and it really puts the obligation to the member states to take appropriate legislative, administrative, or other measures to give effect to these provisions set out in the convention. And this life cycle is actually also described within the explanatory report of the convention. And it is stated that it's any and all activities from design of an AI system to the retirement, no matter which actor is involved in them. So public authorities, private actors, whatsoever. Every time, all these principles need to be guaranteed, no matter where in the phase of the development or the life cycle of the AI system we are. And so it does cover planning and design, data collection and processing, development of the AI, including model building or fine-tuning, testing, verification, and validation, supply, making the system available for use, deployments, operation, and monitoring, and then, of course, the retirement. So extremely broad, and not only on really creating a safe AI or putting it on a market, but really a broad concept of AI protection, the life cycle of AI. What are the state's obligations when they become a contracting party to this AI convention? Let me first put that it is a convention. So that means that contracting parties, members actually of the Council of Europe, can decide to become a contracting party to this convention. They have the freedom to decide on their own. But once they are a member of the convention, once they are a contracting party, it really becomes a legally binding instrument under international law. At the same time, similar to the previous convention that I mentioned, the Oviedo Convention on the patient rights, also this convention is just a framework convention, meaning that it leaves really the scope for contracting parties to translate the provisions of the convention to their specific country situation. So they can really decide how to adapt their policies, their own policies, to these principles mentioned in the convention. And actually, when we look at the responsibilities of the contracting parties, there are mainly three domains in which they have responsibilities. First of all, they have to ensure that AI systems and the entire life cycle of AI systems comply with the following fundamental principles, such as human dignity and individual autonomy, equality and non-discrimination, respect for privacy and personal data protection, transparency and oversight, accountability and responsibility, reliability and safe innovation. So really from the human rights perspective, these are crucial aspects. And when we translate them into the healthcare field, we of course see that many of these things will match with how we look at patient rights quite broadly within the healthcare domain. So it will have some effects when contracting parties become a contracting party of this convention, how they will have to apply also these principles adapted to the healthcare domain to these life cycles of AI systems. The second obligation of the contracting parties is actually to provide information and to guarantee that if a person wants to complain for some kind of reason about the fact that these principles were not guaranteed, that it should be an effective possibility to lodge a complaint. So first of all, member states will have to document relevant information regarding AI systems and their use, and also make it available to the affected person. So it must be sufficiently possible for the people really to challenge the decisions made through the use of a system based substantially on it, to challenge the use of the system itself. So they really need the information in order to be able to challenge these decisions. And these challenges then should be made by an effective system that will rule on the complaints made to competent authorities. So this means effective procedural guarantees, safeguards rights to affected persons. And finally, persons should also be noticed that one is interacting with an AI system and not with a human being. Certainly within the healthcare domain, should be, as patients, be informed of the fact that AI is being used within our treatment is quite crucial when we have to guarantee as a member state that this principle is respecting or being respected by the AI system. And then finally, and here comes really the overlap with the AI Act of the European Union, risk and impact management requirements are also within the responsibilities of the contracting parties, basically meaning that there should be some kind of risk and impact assessment tool available that actually assesses the impact on human rights, democracy, and the rule of law. It should be efficient and sufficient in order to prevent and mitigate measures as a result of the implementation of these assessments. And also the authorities should have the possibility, based on these assessments, to introduce bans or moratoria on certain applications of AI systems. If we link this to the European Union's AI Act, then we of course see the quite similar things. The risk-based approach of the AI Act really comes to the same conclusion as here within the European Council of Europe's approach. The current situation of the AI Convention. So the AI Convention was adopted in the beginning of this year, in the first part of this year, on the 17th of May, by the ministers of the Council of Europe. And based on this adaptation, it was then opened for signature in Vilnius on the 5th of September. And as you can see, a couple of countries have already signed. Inter alia, the European Union has signed it, so therefore certainly interesting to see. If you compare the two, it's a bit weird actually that the European Union has signed the convention. Just to make it clear, the European Commission has signed, but this does not mean that it's already part of the entire EU system. It means that it still has to undergo some kind of procedures. The Council of the EU still has to approve it. There should be still a vote on Parliament. And if we compare this with other procedures, there are some doubts where it will easily come to a conclusion. For example, the European Union is already since 2013 in the process of signing the European Convention on Human Rights in general, but it's still not finalized yet. So if it takes like 11 years or more to become a contracting party of the European Convention on Human Rights, you can wonder whether it's also, or whether it should also be the case with regard to the European Convention on AI. And also doubts with regard to what this linking of the EU will be. Will it be linked only to the competences of the EU itself? And since the EU focuses more principally on the economic and market aspects of AI systems, that's not the same as what the Council of Europe does. So questions still remain on how this will be applied and what the conclusions or consequences of this being a part of the AI convention will be. The European Commission has stated that they will implement the EU by means of the AI Act itself. But since the application, the field of application of the AI Convention focusing on the life cycle of AI is much broader, or certainly different than the approach taken by the EU, questions remain on how it will really be influencing how AI systems are being treated within the EU. It does just simply focuses on different approaches. The AI focuses on streamlining products, whereas the AI Convention of the Council of Europe centers on the protection of fundamental rights of people. So we do have some overlap, being this assessment tool on human rights within both conventions, but there's also quite a lot of differences. So it still has to be explored how this all will work out. If you then shortly look at the impact on the healthcare sector, my main conclusion is actually a question mark, a big question mark. Still of questions remain open when it comes to how will this AI convention affect healthcare? Questions such as, will individual countries within Europe still have to sign and ratify the convention, or is the signature of the EU sufficient? What with health AI that does not fall under the AI Act, but does fall under the AI Convention? What with the links with the Oviedo Convention, the Patient Rights Convention, and what with all this other ongoing work of the European Council of Europe, such as the access to healthcare, mental health, etc., etc. So to conclude, the Council of Europe's AI Convention on Human Rights certainly has high importance when it comes to healthcare protection. Certainly, since the focus is not only on economics and internal market aspects, but on human rights and democracy and the rule of law, and therefore really focusing on this patient rights perspective quite generally. At the same time, with regard to clarity, it's quite low. A lot of questions remain, depending on also the initiatives taken by the contracting parties, and certainly with regard to the question, what will the effects of the EU as a party will be, also with regard to the health domain. So a lot of questions remain, but at the same time, also a lot of opportunities will come up when implementing this AI convention, certainly within the healthcare domain. Thank you for your attention.
Thanks. Thank you very much, Tom. We're going to move straight on to Professor Timo Minssen, who is joining us from Denmark, and he's on quite a tight time scale too. So if we could move straight on, there will be some time for questions afterwards.
Okay, then I go right into medias res. First, a few disclaimers here. So serving as a member of the WHO committee, doing some consulting work funded by the Novo Nordisk Foundation, and also by an EU grant. So today I would like to talk about the significance of the AI Act, the European Union AI Act, in a complex regulatory landscape, and in particular, the applicability of the AI Act to regulated medical products and its interface with the medical device regulation. So the focus is very much on medical devices here. Then I hope I can have some open issues and discussions with you, or discussions about open issues, which then lead me to some conclusions. So what we really see is that AI and machine learning enabled devices are revolutionizing medical diagnosis and treatment. It's not a hype anymore. It's really happening. Our data that we have found in our research at CeBIL really shows a robust rise in patenting of medical AI, in particular in the medical device sector in this area. And the number of medical devices that incorporate AI and machine learning also really continues to increase. So the FDA already reviewed and authorized more than 950 AI machine learning enabled medical devices. And of course, appropriate regulation of AI and medical devices is really crucial here. And here is the significance of the AI Act and its interface with the medical device regulation cannot be overstated here. It really complements the medical device regulation. That said, all these recent activities, Europe is really a world champion in regulation. Let's see, what about innovation and product adoption, but in regulation we are. So these new developments are happening within a very complicated regulatory ecosystem that is interacting with this AI Act and the medical device regulation. As for the health sector, I think most important are the medical device regulation, the general data protection regulation, obviously the EU AI Act, which will be the focus of today, and of course also the European health data space. And a couple of other regulations which we don't have the time to go into, but once again, my point that this is really a very complicated regulatory jungle that you need to navigate carefully, which is, and we come back to that, an issue but in particular for small and medium-sized companies. Big companies, they can see this as a competitive advantage because they have strong, effective regulatory divisions. But for the small and medium-sized companies, which are to a great extent the backbone of the European industry, we don't have Microsoft, we don't have Google in Europe, as they don't have the seat in Europe. So we really need to protect our small, medium-sized entities, and this is an issue. Regarding the implementation of the AI Act, it is staggered. It has been published in the official journal of the European Union on 12th of July. But for high-risk systems, and under these, most of medical devices, they fall under the high-risk systems. There is a general grace period, and it ends on the 2nd of August 2026, when the bulk of the operative provisions comes into effect. So this is important to bear in mind. So of course, we have been busy in this area, published a lot now on the AI Act, about the different challenges and issues we see in JAMA, New England Journal of Digital Medicine, New England Journal of Medicine AI, and Nature Digital Medicine. Today I want to focus of this publication in Nature Digital Medicine, which is about just navigating the EU AI Act and its implications for regulated digital medical products. It says forthcoming. The paper has been published 2 months ago. So then how does the AI Act apply to regulated medical products? First of all, let's look at the basic features of the AI Act and their relevance for medical products. So one is the applicability and the territorial scope, because the AI Act applies to providers placing AI systems in the European Union, in the EU market, and also outside providers, users, if their AI system outputs are used in the EU. So there is an extraterritorial reach, which is similar to the GDPR. What about then the interactions with other regulations? The Act interacts with existing regulations like the MDR and the GDPR. And as I stated before, you must navigate a very complex landscape. There is room for some synergies, which I go into later, some standards and technical documentations that can be used across these legislations. But of course, generally these are all regulations, so they apply in parallel, although they interact. So potentially you could be fined if you do not comply under each of these regulations, which is of course making the matter more complicated. Also important is there is an incident reporting and post-marketing monitoring, or there are requirements with regard to these issues. And developers of high-risk AI systems, including those used in medical products, are required to set up reporting systems for serious incidents and engage, of course, also in post-market monitoring. Non-compliance with the rules can lead to fines ranging from 7.5 million or 1.5% of turnover to 35 million euros or 7% of global turnover, depending on the infringement and size of the company. So there are many articles that apply to medical devices. I can't go through all of them. This is just a quick overview. I will focus only on the most relevant ones here. I also would like to restate that the high-risk AI systems category in the risk classification that I'm sure you already have heard about under the EU AI Act, they fall mostly under the high-risk AI systems in Article 6 and 7. And here again, it shows you that the products or product safety components category under these AI high-risk systems is covering medical devices and the regulation, the MDR, and the in vitro medical device regulation that apply to these. And this, of course, leads to a series of further requirements and compliance requirements, which I will go through now. So how are they regulated then? So the EU AI Act classifies the AI systems as high risk, as I said. This is the highest risk classifications for permitted users of AI. It triggers many compliance requirements. Article 8, risk management becomes a focal point. Article 9, and it also interacts with the MDR risk management to identify, evaluate, and mitigate reasonably foreseeable risks that high-risk AI systems can pose to health, safety, or fundamental rights such as privacy and data protection. So like the medical device regulation, the AI Act applies this risk categorization. There are some very slight potential differences, but also similarities, which in the worst case can lead to some legal uncertainty. Very important is the data governance, Article 10, which is a critical aspect and aligns with the GDPR to safeguard patient data, but it is materially extended in the AI Act with AI-specific requirements relating to training, validation, and testing dataset. And this includes an assessment of the availability, quantity, and suitability of the datasets that are needed. And here it interfaces with the GDPR, but it's more like a lex specialis on this AI system. Also, which is interesting, it is quite a sophisticated regulation in terms of bias groups and categories. So there must be an examination in view of possible biases that are likely to affect the health and safety of persons and takes into account the characteristics or elements that are particular to the specific geographical, contextual, behavioral, or functional setting within which the high-risk AI system is intended to be used. And providers established outside the EU will need to appoint an EU authorized representative. In Article 25, you will find that. It's of course important, particular to Chinese and Asian companies as well. Okay. So what are then the technical documentation requirements? Is it possible to combine them within the medical device technical file? So this requires, the AI Act requires technical documentation to demonstrate the high-risk AI systems complies with the requirements. And this includes minor subcomponents since it is a high-risk category. Again, you have to look at Article 6, which then here interrelates with Article 11. And it needs to be completed and available before the system is placed on the market or put into service, and must be kept updated. In Article 11, you see that. So, and these are comprehensive requirements. I talked already about the headache for small, medium-sized companies. These are requirements that exceed FDA standards under 5010K or the novo pathways, which is important to bear in mind. And yes, so as I said, big companies will find a way to comply with this. Small, medium-sized companies might suffer. And the Annex 4 of the AI Act includes detailed descriptions of AI systems elements and development process of its development, including design specification, system architecture, key design choices, data requirements, training methodologies, computational resources, validation and testing procedures, performance metrics, and so on. And the Annex 4 requires technical documentation for the AI system in addition to the, sorry for the spelling error there, requires technical documentation for the AI system in addition to the MDR or the in vitro medical device regulation. But Article 11.2, and this is interesting, provides the legal basis. So Article 11, Section 2, it provides the basis to create and maintain a single technical documentation file containing the combined information. So medical device manufacturers will rely on Article 11, Section 2 to leverage their MDR and IVDR technical documentation system and expand documentation of AI systems by appending the Annex 4 information. As I said, could it be detrimental to new entrants, these high bar documentation requirements? And there are some provisions in the AI Act that should protect SMEs, small, medium-sized entities, to provide a simplified technical documentation. But the conditions and the requirements for this are still to be developed by the Commission. But it is really highly urgent because it is targeted at the needs of SMEs and should be curtailed to the needs of SMEs. And this is a very important development to follow, where also concerns should be raised in any public consultation procedure. The AI Act also emphasizes the need for safe and ethical AI deployment and sets forth prescribed requirements for traceability, Article 12, through record keeping and automatic logging, AI system transparency, Article 13, and human oversight, Article 14. So, of course, I don't have the time to go to the details and then weeds of all of this, but this is just to give you an overview. Also, Article 15 specifies the design and development requirements for high-risk AI systems regarding accuracy, robustness, cybersecurity, and resilience throughout their life cycle. And you might have heard, I'm sure you have, and you're very much aware of the update problem. So it is really important not only to see the AI system as a locked system, but as a system that continuously develops through the life cycle and the lifespan of the medical device and can improve or it can get worse. Hopefully it will improve. But of course, it demands a capacity at the authorities and in the companies to have people in place that can monitor this and systems in place that can monitor this and that can continuously assess the safety and efficacy and efficiency of the technology. And as with Article 13 on transparency, emphasis is placed here on the provision of information such as the full disclosure of the levels of accuracy, including its metrics with which the AI system has been tested and validated on and which can be expected, as well as any known foreseeable circumstances that may have an impact on the expected level of accuracy, robustness, and cybersecurity, which is, of course, an extremely important area, in particular when we look on the new technical developments in cyber security and, for example, the interface of AI and quantum technology. So this is a very important topic, I would say. So providers are responsible for ensuring their higher risk systems are compliant with the aforementioned requirements. Providers must implement an AI quality management system, the AI QMS, to ensure compliance. In Article 17, you find this. And the quality management system is the foundational building block to ensure ongoing quality and compliance. Again, Article 17. And the AI Act and the quality management system then brings together the required AI documentation, Article 18, conformity assessments and automatically generated logs, Article 20, corrective actions and duty of information, Article 21, post-market monitoring, Article 61, reporting serious incidents, Article 62, and internal and external audits and cooperation with the competent authorities, Article 23. And so manufacturers of regulated digital products and medical devices already have obligations to implement a quality management system to under the MDR and the in vitro device regulation. And then is the question, can these be integrated? Can we use synergies here between these different systems? And do they need to meet the new standards if the AI system in a medical device or a software as a medical device? And the AI Act states, for providers of high-risk AI systems that are subject to obligations regarding quality management systems under sector union law, the aspects described may be part of the quality management system pursuant to that law, Article 17. So in our view, it is likely that the medical device manufacturers will continue using the ISO IEC 13485 quality management system standards, and also incorporate the requirements of Article 17 within the existing medical device QMS functions. So this is what we foresee, so that these new standards can be merged and can be combined within these standards. Providers, authorized representatives, manufacturers, importers, distributors, and deployers, they face distinct responsibilities. You see the articles here, each are regulated in different articles. The overarching goal is, of course, to ensure a high standard of compliance throughout the product lifecycle and along the entire AI value chain, Article 28. And the AI Act also sets comprehensive frameworks for conformity standards, including an EU Declaration of Conformity, Article 48, CE marking of conformity, Article 49, registration, Article 51, and the EU database for certain high-risk systems for oversight and transparency. All of these are very important regulations and articles in the AI Act that systems developers, authorized representatives, manufacturers, importers have to be very much aware of. So as a discussion point now, of course, the AI Act's main goals are better safety, transparency, and accountability for AI system. It is a comprehensive, very broad approach seeking to set a global benchmark for AI regulation, stressing the ethics, human rights, and responsible deployment of AI. So it aims to set up a regulatory framework promoting these goals while encouraging innovation. So the question is if we got this delicate balance right here, because there is always a risk for over-regulation, as there's a risk for under-regulation. And we are, due to our precautionary principle in Europe, might tend a little bit here to the risk of over-regulation. And the question is, what does this do to our competitiveness and innovation? What does it do to our SMEs? Shouldn't there be maybe more adaptive forms of regulation that take in new developments that are not so static, that might lead to better solutions? And of course, other countries will very carefully close now the development, not only on the roots of the AI Act, but also how these are implemented, because that's really where the devil is, in the detail of the implementation and the capacity of the authorities and the companies that need to comply and implement with this AI Act. So ideally, of course, it encourages development of advanced systems. But, you know, as I said, there is some legal uncertainty because there's some possibility for small, medium-sized companies to and other companies to merge their compliance work. But what similar requirements mean under the MDR and the AI Act might cause some confusion. Also, the implementation requires concerted efforts by diverse stakeholders, including policymakers, regulator, notified bodies. There is, of course, a risk of capacity bottlenecks, which are already indicated, a lack of synchronicity, for example, with regard to regulatory sandboxes that are also part of the AI Act. The regulatory jungle could be problematic for companies. So this is, I'm running out of time, so I very quickly run through some issues here that I see. Also, advances in large multimodal models and the applications in healthcare might result in regulatory challenges because of the intended use. For example, some of these models may have multiple uses that may not be clearly determined ex ante. And this is, of course, especially problematic where regulated medical devices are combined with general purpose AI models developed, for example, by a third party. So this might lead to some challenges here. And then, of course, the dynamic pace of AI innovation might suffer from a static regulatory approach. And these four main concerns are really emblematic and typical when horizontal regulation of fast-changing enabling tech such as AI is imposed on sectors with existing regulatory regimes. And these regulatory interoperability challenges must be monitored and addressed in a timely manner before they really cause a chilling effect on innovation. So conclusions, it applies a comprehensive risk-based approach to AI Act. It aligns and interacts with existing regulations. It has a strong impact across healthcare. The goal is, of course, to shape the future of AI with the goal of fostering innovation while ensuring public trust and compliance. The question now is if this trade-off and this balance has been achieved, and if we could not have work better with more, adaptive regulation. We already see that in the medical device regulation, which has led to huge headaches among companies, and the EU Parliament now is already requesting a review and changes to the medical device regulation. And we might see several things in the AI Act. The AI Act has a lot of flexibility still incorporated there. The EU Commission can issue delegated acts that address some of these static versus EU innovation system in flux to deal with that. The question is if this more flexible solutions that the AI Act still incorporates are enough. Thank you very much, and I think I need to stop here because I'm running out.
Thank you very much, Timo. That was a virtuoso tour of the European legislation. Can I invite now Yuan Stevens to come and give her presentation? Yuan is an academic associate at the Centre of Genomics and Policy at McGill University, which is what I have come to think of as one of the sort of three corners of the Hong Kong, Cambridge, Montreal triangle. And she's going to talk to us about From Code to Care, regulating AI in Canadian healthcare. Thank you.
Hello, everyone. It's such a pleasure to be here. Thank you so much for having me. I will try to stay on time. I know that there's a lot of content today. I'm going to give you even more content as well, so please be ready. I'm really happy to be able to share about the Canadian experience and how Canada regulates AI. In terms of what we'll discuss today, I'll just tell you a little bit about me. I want to define AI. I noticed that we haven't actually necessarily defined AI, and I'm going to do that for the purposes of this discussion today. And I'll define generative AI as well. I want to talk about some of the core challenges that I've noticed in terms of regulating AI, the key social, ethical, and legal issues that the technology raises. I want to ground this in a hypothetical situation to make things concrete. And I also want to talk about how Canada's medical devices regulation covers AI, which is pretty robust, in fact. I want to talk about a proposed law on AI, which is quite interesting because Canada is one of the few jurisdictions that has proposed enforceable laws on AI. And then we'll see that there's, as mentioned, robust medical device regulation in Canada, but that there's some significant gaps with the law ADA, which is the AI and Data Act in Canada. So about me, I'm a legal and policy researcher focused on AI governance. I attained my JD in BCL, so Joint Civil and Common and Civil Law degrees at McGill University, and I have a Master's of Law and concentration in Law and Technology from the University of Ottawa, which is one of the most pretty cities but boring cities in Canada. I've also been focusing on technology, law, and policy for 9 years, and I've been working on AI for 7 years since I worked at the Berkman Klein Center for Internet Society at Harvard University when we talked about big data. Those are the terms that we talked about then, and since then, I've seen quite a few hype bubbles, as I'm sure you guys have all witnessed as well. Since March of this year, I've been focusing on the ethical, legal, and social dimensions of using generative AI in health at the Centre of Genomics Policy, McGill University, which was founded by Bartha Knoppers. And unfortunately, I don't Never got the chance to work with her, but she's an amazing person, and she's obviously a very important person in this space. So I'm in the legacy of amazing people. I stand on the shoulders of giants. So for the purposes of our discussion today, I wanted to talk about what I think of when I think of AI. And I really wanted an interactive component to this, but unfortunately, the short time span and how much I wanted to cover meant I couldn't include that. But with that said, when we think of AI, we think immediately of technology. But AI is also a set of socio-technical practices. It's what communication scholars would consider an assemblage. So it isn't just an artifact, but it's also the norms and the actions that are taken that constitute what AI is. AI is also probabilistic. So we know that what happens when AI systems are made is that AI systems are trained on significant amounts of data, and it recreates the probabilities and the patterns that are associated with the data that it's been trained on. Algorithms are also what make up software, what make up AI, and you can think of algorithms as recipes. They consist of if-then statements. So if X is true, then Y will also be true. A subset of AI is machine learning, and parts of what machine learning involve supervised learning, unsupervised learning, reinforcement learning, and reinforcement learning is particularly important in the context of generative AI. So supervised learning is when data is labeled. So we know that there's certain kind of patterns that we're kind of going to be looking for. So therefore the data has been cleaned, probably it's been, think of a spreadsheet and there's columns and rows, for example. Unsupervised learning involves data that has actually not necessarily been labeled, but the data is being fed through the system and the system will find patterns that we might not even know are there. And reinforcement learning is when you train a system to seek a certain reward. So one thing that really struck me in the last year is when I learned about OpenAI and how they actually trained an agent to play a video game. It was a video game that involved racing on water. And normally when you play a racing game, you want to be first. And what OpenAI did was they trained the system to actually maximize points. And it was a really interesting example of the limits of reinforcement learning and how you have to train systems to consider multiple factors. Because what happened was, and you can read about it online if you just Google, OpenAI game reinforcement learning water, if you want. But what happened was the agent actually had a little, character that found a corner and it started spinning in circles to collect points, and it caught on fire, which kind of surprised me and kind of puts into context some of the fears that certain AI governance researchers have around alignment and the fears that perhaps AI will be uncontrollable one day. But I don't think I'm ready to wade into the, super doomsday related fears of AI. And I don't think that's the purpose of today, but I just want to say that that's a whole stream of thought and area of research, and reinforcement learning is an important aspect when it comes to generative AI, specifically because of rewards and the things that we can teach systems to do or seek. Neural networks and deep learning are also important aspects of AI, but we'll just touch on that very briefly. Now it's basically, and when we're talking about neural networks and deep learning, we're talking about the pursuit of trying to teach AI to think like humans. We'll have multiple layers, maybe thousands of data points, and even layers of data at issue, which means there's significant amounts of data in question. And one of the things that I've noticed and other scholars have noticed is that once we integrate AI into society, we actually stop calling it AI. So decision trees are a type of AI, at least they were in the 60s. That's when you have a drop-down menu, you say, do you want this? And it leads to all the other options. That used to be conceived of as AI, but we don't think of that as AI anymore. Other examples of AI more concretely include spam filters. So the fact that your emails can actually be, sifted through based on things like patterns in the data, that's a type of AI that we don't even think of as AI anymore. Character recognition, image recognition, as these things are going to be integrated in society, it's fair to say that we won't really see them as AI or aberrations from the norm. And generative AI, I'm sure everyone's familiar with it here, but I just wanted to touch on a sort of collective definition based on today and what we're going to talk about. What's significant about generative AI is it's broadly being used, general purpose systems. We also have the possibility for a computer to generate text, image, video, and other outputs that are similar to what humans can generate. It's also important to recognize that generative AI has long been used in various creative fields like CGI for movies and image and text generation, but it's been available to the general public since about 2022 thanks to OpenAI. And as mentioned, these systems are trained on significant and massive amounts of data, for better or for worse. And I say for better because obviously that makes them so powerful, but for worse because they replicate the biases, the patterns that exist in that data. And as I think it was Timo Minssen just mentioned, AI is actually already being used in healthcare. It's being used for clinical note generation. A friend of mine went to the doctor recently and the doctor said, "Can I use an AI tool to record our conversation and generate notes for me?" And my friend said, yes. That's really significant. And we're also seeing AI being used for things like virtual assistants for chronic condition management, which we'll touch on later as well in terms of our concrete example today. So I'm going to remain a little bit high level in the next few slides, and then we'll get a little more nitty gritty. But there's core challenges in regulating AI, which I think are really interesting. The first is that tech companies have immense lobbying power and social cultural sway. I think it was Oliver Quick who talked about this a little bit when he talked about innovation first and safety second as a sort of UK driving force in terms of what's happening there. I'm critical of that. I'm not a techno-utopian myself. I try to be more realistic. But as we've seen, people like Sam Altman, Tim Cook and other people who are at the forefront of tech companies are incredible at crafting narratives around how beneficial their technology is, around how it's inevitable in their eyes. And they think of technology as ultimate solutions to solve the world's problems. And I don't know if you saw, but Sam Altman said last week, I think it was, that apparently 2025 will be the year that we have AGI. And that's actually a narrative, right? This is a spin. This is something he's doing to get attention. It's effective, but I think we should keep that in mind when we talk about why it's so hard to regulate AI. From a philosophical point of view as well, you have utilitarian views and the benefits of AI, particularly in the context of healthcare. So I admit that when we think of AI, it's actually quite exciting to think that AI could be used to fast track diagnoses of cancer, for example. And if that is possible, the benefits of that would seem to outweigh its harms. But this is a tension that exists in regulating AI because how do we harness its benefits without its harms or reducing the risk of harms? And that's really what laws on AI are trying to do. The last 2 points are that there's informational asymmetries, which I think is a gap that's closing. So, those who've been able to create AI tools they have a lot of power because their skills are rare and scarce. So regulating the activities of people who can do things that we don't know we don't know what is happening or how that happens, it's hard to regulate that. But as we'll see, regulators in the UK, the US, and Canada have actually come up with principles that guide the regulation of AI in ways that are actually pretty nitty-gritty and I think quite useful and important. Lastly, software is digital. It's much easier to stop the spread of something like a car or sharing a car or a physical device than it is to stop someone sending a piece of software to someone. And that's really important in terms of the actual challenges of regulating AI. The next thing I want to talk about is something I'd love to write a paper on, and you really need to do this. And I'm workshopping this, so please give me your feedback. But I've been thinking about AI for 7 years. And arguably, perhaps I've been thinking about it longer because I'm a big sci-fi nerd and I've been thinking about the possibilities of AI and technology like that and its impact on society. But what I've noticed is that if you look at laws on AI and principles, they tend to address these issues. AI poses challenges to, first of all, the epistemic authority of humans. We see this as a really important issue in the healthcare context, particularly because doctors are really, they're experts. But if you have AI making decisions, then all of a sudden the question is, what if AI is better than doctors? And this is something that Professor Raposo mentioned earlier. Related to that, you have human autonomy. So if AI is, again, going to be really good at analyzing data, do we want AI to be making decisions for us? We might also succumb to automation bias, which is the idea that you can trust a system because math is involved, computational systems are involved. Therefore, we can see it as more rational than us. Reliability of information, factualness, these are also all called into question when AI and particularly generative AI is used because of the fact that hallucinations are possible. So if you ask actually like Claude or ChatGPT enough questions, you can actually have information come out that isn't true at all. And I wanted to talk about this today, but there isn't time, but AI also challenges, of course, privacy, data protection, and personality rights. And I really wanted to include personality rights as a sort of artifact of civil legal systems and traditions, particularly because this concerns the rights over your likeness, your image, your voice. And certain laws like the EU AI Act have addressed things like the possibility of AI being used for deepfakes, but Canada's law has not addressed that at all, actually. So just to finish this off, these topics, we've heard about these things a lot. It's almost like a vocabulary around what it means to regulate AI properly, and this is part of that. But AI also poses issues to knowability. So this is something that I think we were talking about earlier. You were saying, I'm sorry, I didn't catch your name, but you were saying that, do we need to know about how AI systems work? I would argue yes. I think that we know how software is built, we know how pencils are made, but we want to know how AI has come to decisions and outputs, because we want to be able to challenge whether that's biased. It's really important that we be able to do that. With that said, AI also challenges notions of fairness and equity. Because if AI is going to replicate, for example, things that humans have said, or certain decisions that have been wrong, don't we want AI to maybe help us usher in a better world, one that where at least the possibility of bias as a risk is reduced? Last two things is that AI also challenges the rule of law, which isn't a huge discussion today, but is a really important issue. So you'd think that if AI is going to be introduced into court systems, shouldn't AI be governed as well? How do we hold AI accountable when we're going to be relying on it in things like court decisions and in judicial reasoning? Lastly, environmental and ecological sustainability is a huge issue that AI raises as well, for obvious reasons related to the amount of power environmentally that AI takes to run. So when I was preparing for this, I decided to produce an image. I put into ChatGPT, which you use when you want to use DALL-E. I put in the prompt, generate an image of generative AI. And I just wanted to kind of recursively show you what's going on here when we talk about AI. So as we see, DALL-E produces beautiful image for me. I don't know if it's actually beautiful, it's just very interesting. We see a brain, we see sort of pictures of, there's almost like a hopefulness in the image. There's circuits, and I raise this just because I think it's interesting to think about how generative AI is in fact changing things. And in the image that generative AI generated, we can see values encoded in that system and in the output. So to ground today's discussion in something concrete, let's imagine this is actually possible. There's many tools that exist like this. Let's imagine as we are all the company, we are working at a company that has made a tool called Diabetes Assist. This is not a real tool. It's a virtual assistant for diabetes management. Its key functions include analyzing user data and providing personalized recommendations to help manage blood sugar, diet, exercise, and medication. It has the potential functions as well of logging voice to text data, so someone can speak and it'll turn into a text. It might even have a chatbot, so it'll be chatbot, ChatGPT-esque, in that maybe you can converse with the tool and will provide you recommendations. It can potentially engage in sentiment analysis, both of your text and also maybe even of your face, which is interesting. And it could potentially even be equipped with the possibility of alerting medical professionals based on your situation. And all of how invasive it is will will correspond with how risky the tool is as well. So let's turn to Canada. How does Canada regulate this under our medical devices regulation? I'm going to get a little bit technical, describe it, and I'll tell you some of my conclusions. So Health Canada is an entity responsible for the Food and Drugs Act. Medical devices regulation is a subset of that act. The TLDR in Millennial and Gen Z speak, or summary, is that the law is based on record keeping and licensing. And I don't have a lot of time, so we're going to have to speed through the next content, but I will share these slides online. So in short, it's a risk-based law. You get a license based on how risky your tool is. There's many factors at play. And these are the documents. Again, I'm going to have to rush through this, unfortunately, due to lack of time. But these are the documents that actually inform medical devices regulation in Canada, and it's pretty robust. So we have the lowest class, which is thermometers. Higher risk is things like ultrasound equipment. And when things are machine learning enabled, you have to have clinical evidence of your safety and effectiveness available upon request. There's riskier devices, so ventilators, pacemakers, things that are invasive and are in your body that can actually be used for decision making as well, in terms of actually impacting decisions that you make in terms of your health. And for these devices, you absolutely need clinical evidence on safety and effectiveness, and you also need evidence available upon request if it's machine learning enabled in terms of clinical evidence as well. So this is a bit of a fuzzy image, but this is from a guidance document in Canada on how to classify devices. It seems to me that Rule 9 comes into play because we have dedicated software that's intended to administer or withdraw energy to or from the body. And it doesn't seem like the other rules apply here, so we have maybe a class 2 device. There's complaint handling and accounting for problems as part of this law. We have post-market monitoring and incident reporting, which makes sense. You want people who, if they've been adversely impacted by technology, to be able to complain under that law, of course. We also have this guidance document, and this is where we see the law get a little more flexible. And this is because of the challenges relating to regulating AI, as mentioned. I'm going to skip over this just in the interest of time. And this is a chart that is, taken from that document. But the summary here is that the more serious the healthcare situation and the greater the software's impact on decision-making, the higher the risk category is for the software. I really actually quite like this document that the US, Health Canada, and the UK have put together. You can tell that they really worked with AI experts on this, and there's 10 points, and I'm not going to talk about all of them here. But some of the things that struck me is that some of the requirements or principles really are things like training data sets should be independent of test data sets. So someone else earlier mentioned overfitting. I think it was Tommy Lam Kam Chun. Sorry if I'm not saying your name properly, but I remember that you said this. And the idea here is that you have an expert, but you need your AI system to be an expert in all areas and not just be really good at analyzing one type of data. There's other best practices around using best available methods for data. And I'll let you kind of read through this in your own time after, but we have many other considerations in this document that are really helpful in terms of providing clear and accessible information. And as I call it, you want to get AI out of Plato's cave. This is what I mean when you say training the AI system on generalizable, diverse, and representative data. So there's more documentation that we'll skip over really quick. And I'm going to talk in the last few minutes on our proposed law, AI and Data Act. This is a sort of risk-based law that is essentially at its core sets out record-keeping, transparency, and accountability requirements for AI systems in Canada. A little bit of a focus on ensuring human oversight. It was proposed 2 years ago, and it's also part of an overhaul to Canada's private sector privacy law. It's been a controversial law in Canada, though not many people really care that much about what's going on in Canada because we're not as popular or powerful, that is, as the US. We're doing things, and it was a bit of a bare bones law. But in 2023, in order to address these controversies and how sort of oversimplified the law was, our Minister of Innovation, Science and Industry issued a letter to amend the proposed law. And I have a little Frankenstein emoji there because it was kind of Frankenstein-esque and it was an unusual move. And we actually have an election coming up next year, a federal election. And my gut tells me that the law might be passed based on some of the activities of the Minister of Innovation. But it's actually unclear whether the law will be passed. If it's not passed by the time the election happens, then it's going to die on the order of paper. And I wrote an op-ed saying that Canada needs to implement and sort of incorporate human rights at the start of the law, which I hope happens, which would probably mean scrapping the law and starting again. However, just to touch on some of the core issues that this law addresses, it's about serious types of harm. Biased output is a new thing that this law introduced. And I have a question for us, which is to what extent? So I'll let you look at these slides later, which you can find on my website or Twitter. But I think for the purpose of today, I'm going to just sort of hop over to the last few messages I'd love to leave you with, which is that I want to look at the gaps. So there's requirements in this law, but there's significant gaps. It's actually not clear when the law applies to AI used in health. Human oversight is ill-defined in the law. There's data use practices mentioned, but it's neither really meaningfully nor comprehensively addressed in the law. And it also fails to provide individuals with legal recourse. So that's significant from a human rights perspective, because if you can't actually challenge a decision made under the law, then how do you have your rights protected? So it does address some of the key issues as mentioned before. But hopefully I can leave you with the key message here that we actually have pretty robust medical device laws and protection in Canada, but there's really some significant gaps in our proposed laws in AI. And with that said, thank you so much for your time today. Happy to chat after and take your questions too.
Thank you, everybody. If you could take seats, thank you. Right, well, it's my enormous pleasure to chair this final session of an incredibly stimulating and really rich day of presentation and discussion. And we have one final session with some exceptional speakers who are going to be discussing issues relating to regulation of AI in the US and other jurisdictions. So without further ado, I'd like to introduce Sarah Gurka, who is an associate professor of law at the University of Illinois, and she'll be speaking to us on regulation of AI and machine learning in US healthcare, challenges, opportunities, and the evolving FDA framework. Thanks, Sarah.
Thank you so much, and thank you for being here on a Friday afternoon. So my presentation is going to focus on regulatory challenges in particular, which we are seeing in the US in the healthcare system. And I really try to give like a really broad overview of what you need to consider when developing an AI tool in the US. And I was thinking to approach it from a life cycle perspective and looking at the life cycle of health IML-based products. Let's start with looking at the regulatory challenges in this life cycle. So we need to focus on, really need to look from pre-market to post-market considerations. And I'm particularly focusing on pre-market considerations, and Professor Barbik, I think, will focus later more on the post-market issues. Now, first of all, when developing IML-based products, we really have to think, well, is this actually a medical device? Yeah, and why is this important? Because it is really important because only if your product is considered a medical device, the FDA can actually regulate it. Yeah, if it's not a medical device, FDA, even if FDA wants to, cannot regulate it. And so the definition of what a medical device is really important here to consider. And the Federal Food, Drug, and Cosmetic Act has a definition of the medical device, which you can see here. And what's important is in particular this part, which I highlighted here in bold, which says that a medical device is intended for use in the diagnosis of disease or other conditions, or in the cure, mitigation, treatment, or prevention of disease, and does not achieve its primary intended purposes through chemical action within or on the body of man, and which is not dependent upon being metabolized for the achievement of its primary intended purposes. And in particular here, the last sentence is really important because it says that it does not include software function excluded pursuant to section 520. So what does this mean now? So it means, in general, the term medical device also includes software functions. And you can see here on this slide that software can be divided into three types. So-called SAMD, software as a medical device. There is software in a medical device as IMD, and then there's software used in the maintenance or manufacture of a medical device. And if we're looking at SAMD, so software in a medical device, software as a medical device, so this is being defined by the IMDRF, which is the International Medical Device Regulators Forum, and it's defined as software intended to be used for one or more medical purposes that perform these purposes without being part of a hardware medical device. So what this means is SAMD is standalone software. So the software itself is considered the medical device. And so you can imagine an SAMD is operated with non-medical devices, such as laptops, smartwatches, smartphones, etc. A good example is Apple's electrocardiogram app. Yeah, so that's an example of an SAMD. Now, in contrast, we also have software in a medical device, which is also called SIMD. And so here you have both. You have software and also hardware components. And the software really needs to help here the function of the medical device in some way. And a good example is software that helps run an insulin pump. But the majority, and that's really important to see, the majority of the AI tools which we have already on the market in the US, but also are being developed, are SAMD, so software as a medical device. So the software itself is considered the medical device. Now, what's also important to realize is that some software functions in the US are not considered medical devices at all. Section 520 of the Federal Food, Drug, and Cosmetic Act actually lists here 5 categories of software functions that are not considered medical devices. And this means the FDA cannot regulate them. Yeah, so they fall completely outside of FDA's radar and regulatory review. And these are software functions intended for administrative support of healthcare facilities, maintenance or encouragement of healthy lifestyle. So a lot of health apps fall under that exception. Then surface electronic patient records, transfer, store, convert, format, or display data and results. And then the last one is a clinical decision support software exception. And in particular, this last exception is really relevant for AI/ML because it includes software functions that are intended for, and this is now a quote of the Federal Food, Drug, and Cosmetic Act, the purpose of supporting or providing recommendation to a healthcare professional and enabling such healthcare professional to independently review the basis for such recommendations that such software presents. So here this vague term, independently review the basis for such recommendation, is really opens many possibilities for interpretation. And of course, a lot of AI manufacturers try to not fall under the medical device framework and fall outside of FDA's review. Now, if it turns out that you are developing a medical device, an AI/ML-based medical device, then the next question as a manufacturer needs to be to consider, okay, what regulatory pathway do I need to go through? What are the applicable requirements as a next step? And so how it works in the US is that if your medical device is categorized into 3 classes based on its risk. So we have a class 1, class 2, and class 3. Class 1 is the lowest risk, class 2 moderate risk, and then the highest risk is a class 3. And there are 4 relevant types of pre-market submission. The first one is the so-called 510K pre-market notification. So this is for novel, this is for class 1 and class 2 devices, except some of them are exempt and don't need to go through 510K at all. Then you have the so-called de novo classification request. So this is for novel low to moderate risk devices. And then there is the pre-market approval, the so-called PMA, which is for class 3 devices. And then you have also a few other exceptions like the humanitarian device exemption. That is for high-risk devices for rare conditions and diseases. Now, what's important to realize is that the majority of AI/ML-based medical devices that have been permitted marketing from the FDA all went through the 510K pathway. So why is this important? Because in a 510K, sponsors only need to demonstrate that their medical device is substantially equivalent to a legally marketed device, which is the so-called predicate. And so the 510K pathway usually does not require any clinical evidence. And that can be in particular worrisome for some of the deep learning AI. And we already talked about this morning, about black box AI, because it uses really a complex algorithmic reasoning that makes it really difficult, if not impossible, for humans to understand how the AI arrived at its output, making it non-interpretable. Now, the AI/ML-based medical devices that have received marketing authorization from the FDA so far have typically included so-called locked algorithm. And a locked algorithm is an algorithm that provides the same result each time the same input is applied to it and does not change with use. Of course, most AI algorithms are actually adaptive, which is arguably their key strength. And an adaptive algorithm is an algorithm that may change as it is applied to new data. And so the long-term idea of the FDA is to really routinely implement a so-called total product lifecycle approach, which really the idea really is to help to allow these devices to continuously learn and optimize their performance. And what's really interesting and which is really new right now is that Congress has recently passed the way for a so-called predetermined change control plan, which consists of a description of anticipated modifications and also a description of the methodology being used to implement these changes. And now what AI/ML manufacturer now can do is they can voluntarily submit such a plan with their pre-market submission. And if the FDA authorizes this plan, then they can make changes to the AI/ML-based medical device without needing to undergo an otherwise required necessary FDA review. And so this is fairly new that Congress gave FDA now the possibility to implement this predetermined change control plan. Another issue which we are seeing is the labeling of AI/ML-based medical devices. So the problem is that there are no labeling standards right now that are tailored to AI/ML-based medical devices. So there are only general labeling requirements for medical devices, which are listed in Title 21 of the Code of Federal Regulation. But the problem is that those general labeling requirements that we have in place for medical devices, they do not really work well for AI/ML-based medical devices. So for example, here you can see a recent study that out of a total of 161 legally AI/ML-based medical devices in the US, actually only 7 provided publicly available race ethnicity information and only 13 disclosed gender information. And then in addition, most manufacturers also did not report information on the amount of data used to validate the device's performance or the geographic breakdown. And so this study here clearly confirms that the current labeling requirements for medical devices are really insufficient for AI/ML-based medical devices. And the problem is that many, without labeling standards that are tailored to AI/ML, many users are going to be left in the dark about a lot of important information, such as gender, race, ethnicity, and also geographic breakdowns of the data sets used. And without that information, a patient's health may really be jeopardized here by unnecessary treatment or biased care. And so this is why I argue since some time now that it would be really helpful if the following 11 key types of information were included on the label of AI/ML-based medical devices. And those include model identifiers, the model type, the model characteristics, indications for use, validation and model performance, the details on the data sets, preparation before use in applications, model limitations, warnings and precautions, alternative choices, privacy and security, and additional information. I don't have time to go into the details here, but just to pick out a couple of examples. So for example, the label should really provide an overview of the validation and performance results. So in particular, it should list all of the model's cross-site performances to enable users to appraise its reliability. Now, recent research has shown that deep learning models that were evaluated only at one clinical site, which is, by the way, common, can have really weaknesses and perform much worse across clinical sites. Another example, as I already mentioned, is we really need more information about the data sets, such as gender and race ethnicity breakdowns. And this list here should also really not be considered exhaustive, but it should really it should be a start and a helpful tool for regulators like the FDA to begin the overdue development of labeling standards that are tailored to AI/ML-based medical devices. And during that process, the FDA should also maintain an ongoing dialogue here with all stakeholders, including patient and consumer representatives. And then in addition to general standards, labeling standards for AI/ML-based medical devices, at some point, as a second and third step, the FDA and other regulators would also need to think about additional labeling standards for specific types of AI and or specific uses and intended users. Now, regulators like the FDA really need to do a better job here of educating users about the risks of AI/ML-based medical devices. And I think like with the right design, labels could help achieve that goal. So an eye-popping label design, such as, for example, a nutrition facts label, could really have here the advantage that its design is familiar to users and also allows them to get a quick overview of all key information. Now, once a pre-market submission has been successfully completed, the FDA may permit marketing of the AI/ML-based medical device. And so far, the FDA has actually already permitted the marketing of 950 AI/ML-based medical devices. The majority of such devices are in radiology and then followed in cardiology and also neurology. And there are also marketed AI/ML-based medical devices in other specialties, such as ophthalmology and gastroenterology. And out of the 950 AI/ML-based medical devices, the majority, and these are 924 AI/ML-based medical devices, they all went through the 510K pathway. Again, 510K only requires you to show that your device is substantially equivalent to a legally marketed device. Mostly no clinical evidence needed to go through the 510K. 22 of 22 AI ML-based medical devices went through the de novo process, and then only 4 went through the most strict regulatory pathway, which is the PMA, the pre-market approval. Just to give you a couple of examples, this one on the left side is NewBeat newborn heart rate meter. So this is an AI ML-based medical device that is intended to be used in hospitals to continuously measure and display the heart rate of newborns. This is a device which was cleared through the 510K pathway just in June this year. The other one on the right side is an interesting one. This is Luminetics Core, was formerly called IDXDR. And this is a medical device that uses AI to detect more than a mild level of diabetic retinopathy in diabetic patients. And the interesting thing about this tool is that it's the first AI which is considered autonomous because its decision does not need to be reviewed by a primary care physician, and it was already been marketed since April 2018. It went through the de novo pathway, and it has so far been deployed in over 20 sites across the US. So once the AI ML-based medical devices is launched on the market, we also need to think about continuous risk monitoring, which really will be crucial. I think like Professor Warbeck will also talk more about this, but I think in particular for adaptive algorithm, that's going to be a necessity. And then lastly, I want to point out the so-called system view, because I believe that regulators like the FDA need to adopt such a system view. So what do I mean by this? Professor Warbeck and I and colleagues have several years ago wrote a paper on the system view, and we argued that regulators like the FDA actually need to widen their scope in evaluating medical AI ML-based products and really assessing them as systems. So what does this mean, this shift in perspective? So from a product view to a system view. So it's really central to maximize the safety and efficacy of AI ML in healthcare, but it of course also poses a lot of challenges because agencies like the FDA are used to regulate products and not systems. But if you're thinking about an AI ML-based medical device, it's usually really one part of a larger system involving various kinds of human involvement, from a healthcare team inputting the data to physicians reacting on the AI recommendation to insurers deciding whether to reimburse only for certain causes of action. And it's so really the entire system that must be evaluated. And in a sense, it may be useful to reframe what hospitals are actually doing. They are not merely buying an AI ML tool, but they are actually hiring one. So cognitive testing of a physician will also not tell you how they will do when added to a pre-existing team. And the same is also true for AI. They need to be continuously assessed. And this system view, I think, will become in particular important now when we are in this area of generative AI tools like large language models. And so there it will become even more imperative to think about how to assess those systems in the future. I'm going to stop here. And thank you very much for your attention. And I guess we keep the Q&A for the panel later and then the discussion. Thank you.
Thank you very much, Sarah. Okay, yeah, as Sarah said, we will keep the Q&A till the end of this session. So it's my pleasure to invite Professor Boris Babic to come up and speak to us on tracking and governing problems arising from medical AI and machine learning devices. Professor Babic is based here at HKU. He's an associate professor both within the Faculty of Law and the Musketeers Foundation Institute of Data Science and Department of Philosophy. Thank you, Boris.
All right. Thank you very much for the nice introduction, and thank you all for being here. So, all right. So my talk today is going to be looking at what happens, basically what happens with medical devices from a regulatory perspective once they've been brought to market. And this is a little bit niche, but we're going to look at the FDA's system for medical device reporting. So basically, how I became interested in this I assume that there's a kind of substantive regulatory tracking system for what happens with these devices once they're on the market. And when we started looking at it more and more closely, it became pretty clear that like most of this data is actually quite useless for any analysis that you might want to do with it, for a safety perspective. So I'll walk you through the data. I'll give you some examples, and I'll try to make the case that it's not that useful, and we need to move away from adverse event reporting. So one other bit is there are kind of two types of post-market surveillance that the FDA tracks. One is adverse event reporting, and the other is recalls of generally traditional medical devices. So we wanted to study both, but because most AI/ML medical devices have been approved pretty recently, and because they don't have serious malfunctions in most cases that cause things like death, there aren't really any recalls. It was like N equals 2. So we're really just looking at what's called adverse event reports, and I'll tell you about these in a moment. So some of the regulatory background I can go through a little bit more quickly since Prof Gerke went through some of this, and then I'll tell you more about the data, but this is the 3 parts that I want to talk about. So what is the FDA adverse event reporting system? Where does this data come from? So it's the FDA 510K database merged with the MAUDE adverse event reports database. And then I'll tell you why I think this data is of basically limited value from a safety perspective or a regulatory perspective. There's not much we can do with it for evaluating how these AI/ML-based devices are performing. Okay, so some regulatory background. Generally, everything kind of like fits within the Federal Food, Drug, and Cosmetic Act. That's where kind of like regulatory perspective here is. But in this project, we focus in particular on post-market surveillance. So this is AML devices that have been brought to market. And we're going to look at recalls and adverse events, keeping in mind we can't really study recalls right now. So really, it's just adverse events. The FDA's medical device reporting system. So yeah, this is some of the key requirements are all in the FDCA, and it requires manufacturers, user facilities, and importers of legally marketed medical devices to submit reports of certain adverse events. FDA refers to these as MDR reportable events. So these include reports of death, injury, or malfunction. And a malfunction is reportable only if it would be likely to cause death or injury or malfunction. So in the data, we have the FDA's tiered risk system within which we're operating class 1 to 3 medical risk devices. Most AI/ML devices have been cleared under moderate risk class 2 in the data. Moderate risk devices are typically regulated through pre-market notification or more often the so-called 510K process. This process requires a device to demonstrate substantial equivalence with one or more already marketed, legally marketed devices. Class 2 devices that don't have a predicate device can go through a de novo classification request. So most of our data is coming through 510K cleared devices. The FDA maintains a comprehensive 510K database. This is what we start with. We download all the 510K files, restricting to medical devices approved from 2010 through 2013. So we kind of to 2023. So we stopped at the end of 2023. The devices are class 1 and class 2 pre-market notification, and include some de novo classification requests. This represents almost all of the FDA device market authorizations over this period. And we then filter these devices for AI/ML-based medical devices. And in some cases, we compare AI/ML versus non-AI/ML to see how the adverse event report data looks with AI devices and others. We calculate the number of adverse events reports within specific timeframes. And our final data set comprises 823 510K cleared devices. Professor Gerke earlier mentioned 950 AI/ML-based devices. So we basically, we restrict our period to 2010 to 2023. So we have a little bit less than the full set of AML-based devices. The data set tracks 54 features related to the reported events. For example, things include like type of event, the setting where it occurred, the manufacturer, and the product it's associated with. Within these MDRs, there are 20 unique product codes. Okay, so here's some data. So first of all, these are all the unique product codes in their adverse event data. What you might notice right away is that basically there are 3 product codes that account for the overwhelming amount of adverse events in this entire database. So you might think, okay, well, where is this coming from? I will tell you a little bit about where these are coming from. So this is PEX, MBW, and PJA. So PEX is misidentifications of microorganisms, but I want to focus a little bit more on the other 2, PJA and MBW. So PJA is a product called Dario Health, and wait, MBW is, yeah, okay. PJA is HeartFlow, and this is a medical technology that was established in 2007. HeartFlow is used for identifying coronary artery disease. So what it does is it uses CT scans to create a 3D model of a patient's arteries and derives a mathematical quantity that indicates the extent of coronary artery disease. All MDRs of PGA were reported as false negative results associated with this HeartFlow analysis. So basically, it's indications of sufficiently high blood flow when a blockage should have been identified. So it's a false negative in this case. And that could be a real kind of risk, right? Because it should have been identifying a blockage, and it's saying like, no, everything is fine. When we look at the data qualitatively, it's hard to know where these mistakes are coming from. So sometimes they say it's a malfunction, but the actual report said it was an analyst error. So in the end, we kind of like have no idea. MBW is this direct-to-consumer product called Dario, which is used for blood glucose monitoring. And most of these reports involve high blood glucose readings. In other words, these are false positives. So it says someone's blood sugar is high when actually it's sort of like normal. Often they lead patients to seek additional medical devices. It's again hard to know why these happen, because if they're coded as a malfunction, when we look at the data, they're actually described as an analyst error. So a lot of the data is coming from these devices. One thing to note is we don't know whether this is a problem or not. It could be that these companies just are like over-reporting and being very diligent and others aren't, or they could have bad products that are causing some problems. Another problem in the data is that there's just a ton of missing data. So anything we tried working with, like event location was missing for every entry. Whether the person was a health professional was almost always missing. The date was often missing, and occupation of the reporter is missing. So we don't know where they're coming from, and we don't know when they were made. So it's really hard to study any kind of like safety issues systematically when so much of the data is missing. The other problem is misclassification. So we have 3 types of events, right? Malfunction, injury, and death. If you look at death, there's very few. There's just 2 deaths that are coming from MBW. Again, in the qualitative description, it seems like these deaths aren't actually associated with the device, but almost everything else is just plugged into a malfunction. Now, if we wanted to study basically like, let's look at some regression analyses of how safety is affected by location, by event type, and so forth. But then we realized, well, location is almost always missing. Event type is often missing. And even these indicators, everything is just bunched into a malfunction. And when we try to read it qualitatively, it doesn't look like a malfunction. It's described as like an analyst error, but then coded as a malfunction. So we don't know what to do with it. We can't repopulate the data. So there's a lot of things missing, and there's a lot of things that are misclassified. Basic overview though that I want to highlight is after like trying to look at this in detail and see like what can we glean about how much risk AI ML devices present once they're brought to market. I don't know what to say on the basis of the data. There's really not much. So it's not clear to me why there's any value in the FDA continuing to track adverse event reports. They're static, they're incomplete. The people who produce them don't really have an incentive to report what happened. Like if you're the company that makes one of these devices, it's always better to say that it's analyst error rather than your device's problem. So not only are they incomplete, they're also hard to trust. So then how do we improve it? What should we do instead? Well, we want to make two suggestions in sort of the project that would come out of this. One is just, okay, we have some concrete suggestions over how to improve data recording. Some are obvious, make it more complete, right? And actually don't have as many label misclassifications as we've observed. But then also we can track some other things. So there are some important things that are not at all being captured in static data like this and that we could be capturing. And I'll tell you about a few dimensions. So our starting point here is looking at issues that we previously discussed in joint work with myself and Professor Gerke. And in particular, the sort of three issues I want to highlight is what we call concept drift, covariate shift, and algorithmic stability. So these are all important safety dimensions of AI/ML products, and they're nowhere in the post-market surveillance and FDA's current regulatory system. So what is concept drift? Okay, this is the first one. So concept drift occurs where the true joint feature label distribution, the distribution that the algorithm is trying to approximate, slightly changes over time. So you can think about every AI/ML system as approximating a function. It's a function estimation problem between the input features and the label, and that function itself can slightly change over time or across environments. When that happens, we get concept drift. So for example, an AI/ML-based admission triage tool may be tested on a sample corresponding to a general healthcare environment, but then deployed in managing ICU QEs. If you had a pretty high specificity and sensitivity initially, after concept drift, that can deteriorate very quickly. Second dimension that we can look at is covariate shift. So covariate shift refers to a situation in which the feature distribution alone changes as opposed to the joint feature label distribution. So this could occur if the training or early use data is not representative, but it could happen for other reasons as well. So representativeness is something that other people have talked about quite a bit. But just to give you a really kind of simple example, consider an extreme case, a situation where an AI/ML medical device is trained on a sample of high risk for diabetes, obese younger men, and then applied to a sample of high risk for diabetes, non-obese older men. The distribution of diabetes among both of these groups could well be the same, right? The label distribution could be the same, but the feature distribution is very different because the relevant risk factor in these cases is obesity versus age. So this is a case where we have covariate shift without concept drift and without actually a lack of representativeness in the data, but just the feature distribution itself changing. And again, when that happens, the performance of any kind of predictive system or diagnostic system can deteriorate very quickly. Third property is one that I've been calling, that we've been calling algorithmic stability. This draws on, I guess, a mathematical property, a measure theoretic property called the Lipschitz property, which requires that for a given distance between two observations in the feature space, their distance should be similarly bounded in the output space. One can think about this, we can sort of, put in a legal interpretive spin on it as treating like cases alike. But unlike in law, we need to formally represent distance in a suitable measure space to satisfy the Lipschitz property, keeping in mind that the dimensionality of the input space is different from the dimensionality of the label space. This is particularly important in diagnostics and resource allocation. So basically, we want to treat like cases alike. If we deny a kidney to someone in a QE of limited organ donations, we want them to be treated like, the person who is most similar to them in the features which matter to the outcome of the decision. So it's important to satisfy this property. How could we address these? Well, reporting requirements could be modified so as to require, for instance, that for every AI/ML device, manufacturers must flag both when training data is significantly updated and when deployment conditions are substantially amended. We could require manufacturers to produce a quarterly update reflecting these changes in feature distribution, label distribution, and stability. And then a more radical change would be to move beyond database reporting altogether. So Professor Gerke talked about having nutrition label style reporting. We could also combine this with human factors A/B testing, as well as with a system of continuous oversight, which the FDA is moving towards, again, as Professor Gerke mentioned earlier. Okay, and that's it. Thank you.
Thank you very much.
Fantastic. We'll move on to the final presentation of the day, certainly last but not least. This is Professor Barry Soliman, who is Assistant Professor of Law at the College of Law in the Hamad bin Khalifa University in Qatar. Barry has literally partly written and co-edited the book on AI, law and governance quite recently. So it's fantastic to have you closing off the session today. Barry, you are going to be speaking to us, I understand, about the approach taken in some of the Gulf states towards regulating the life cycle of healthcare AI.
Thank you so much, Colin. Appreciate it. Thank you for having me back in Hong Kong. It was a little bit squelchy with the rain last night, but it's dried up a bit today. And I do realize I'm the last speaker before I stand between you and your dinners tonight. Don't want to get in the way of the dinner, the dessert, cheesecake, whatever happens to be there. But anyways, so I shall take you through something that's occurred to me while I've been examining this area, which is I'm seeing a lot of developments which are in specific areas, but I think there's a way of bringing together some of these developments, or at least thinking about it, a bit of a thought process that arises when looking at jurisdictions in the Middle East in particular. So this is the book that you mentioned. I've got to thank Calvin for being a big support at previous events here when this was a work in progress, giving us the stage to share this as a work in progress. And now it's out as an open access book that Calvin has contributed to, the Vera's contributed to, the Sarah Gerke's contributed to, the Tom Goffin and Timo Minssen, who spoke of, contributed to, amongst many of the speakers. So the insights that I'm giving today partly arise from this book. They partly arise from an article that I published in the Asian Bioethics Review. And they arise from a research grant project that I led and has now concluded at HBKU. And they also arise from just conversations I've been having a lot with the Ministry of Health in Qatar and lots of startups that are now not leaving me in peace about the problems they are having with bringing their devices to market. And even I was sitting there at the back and they're emailing me, asking me for solutions I don't have. But I'll speak a bit more about that in a moment. So I think the three countries in the GCC are interesting because they've invested in AI so heavily, and they see them, and they're competitors. They compete against each other to be the best. Qatar's phrase is Qatar deserves the best, and they had this plastered everywhere in the build up to the World Cup. And so it goes with their neighbors. They're all competing against each other. But I think the developments in Qatar, which I'd like to highlight, which we've been working on the grant project, shows perhaps one area, but the first stage where regulations and governance are needed when it comes to AI. So the first stage is research and development, the very beginning. The next stage is perhaps when you create a medical device and the medical device approvals process, which we've heard about from different angles, that will be the next stage. And Saudi Arabia provides a really interesting example as a case study there. In some cases, they've been ahead of the FDA in the US. And then the third stage is, well, what happens in clinical practice once AI is implemented in clinical practice, and how do we regulate it there? So, and there, the UAE provides some very interesting insights that other countries haven't done. And so there is more to it. There's data, and there are other aspects, of course, we can look at. But I do think when we think about AI, we need to look at all of these stages, and there is a bit of overlap between them. But I'll go through it. So, very brief preamble here is to note that in these countries, AI is being used in the health systems quite extensively. In Qatar, it's being used in research and it's being deployed. Same in UAE. Saudi Arabia is deployed it to such an extent that they were AI in one of their hospital systems performed more than 85,000 interventions. I think that was the year before last. I don't have the recent data, but it's being used. One thing we're missing is survey data of knowing the extent to which it's being used, and that's something that has also been coming up in conversations recently. We need to do an analysis of that. So, and then just to give you what the startup companies are concerned about, and it's quite interesting when you actually have a discussion with the companies who are trying to bring products to market. So some startups are stuck in a regulatory no man's land. If you're a startup that's based in the US or you're based in, let's say, Saudi Arabia, and you have an FDA that has some sort of approvals process, you can take your product, you can satisfy those regulators. As Sarah has pointed out, what happens in the US is not too difficult to go down the predicate pathway route. But you can go down that pathway and you can bring your device to market. The challenge for a lot of startups that have been talking to me is startups that operate in a space that doesn't have an approvals process. They don't have an FDA. They don't have any AI guidelines or regulatory approvals processes. And the consequence for them is when they develop a product and they go to the hospitals to sell it, the hospitals say, where's your approvals? And they say, we don't have an approvals process. At the same time, those hospitals are accepting devices from companies that have been developed in other jurisdictions. So if you're operating, if for the hospitals in that case, let's take Qatar as an example. You know, if you're a hospital that is operating in an environment where there isn't a regulatory approvals process, you will be happy to accept a device that's been approved by the FDA or the SFDA in Saudi Arabia or another regulator, but you won't accept a company that hasn't gone through that approvals process. So what's happening for local startups is they're getting swamped by foreign competitors in countries where that doesn't exist. So this is definitely a problem. And it speaks to the need for regulations. And this is been the thing for me in my research recently is these companies reaching out to me, and there's a very consistent thread coming out about this gap. So let's go through then how this might look. And I don't purport to give how it all fits together. This is still, the pieces are forming. But Qatar, I think, gives us an example of the R&D, the first stage of the process of getting approvals for medical devices, for the research and development of AI devices. This is the research grant that I was leading for 3 years at HBKU, which just concluded a couple of months ago, and is currently the guidelines are going through the copyright office at HBKU. So once they are copyrighted in Qatar, I'll be allowed to share them publicly. So I'm just waiting for that process. But this was a project that was run in conjunction with the Ministry of Health, and it involved bringing together a group of experts in different fields. So those in computer science, those in Islamic bioethics, in biomedical research, in the health and life sciences. And we attempted to create guidelines that follow best practices. And in so doing, we also had expert roundtables, meetings with stakeholders in the country, with developers and beyond, to see what they thought of our works in progress. And we went through dozens and dozens and dozens of drafts over the 3 years. And we produced a blueprint for a website, what it might look like, for developers who are seeking to comply with the guidelines and then submit evidence for it. So so this is where, if we think about the first stage, by having guidelines in the R&D phase that may come under a ministry, you may also tick some of the boxes for the later stages of the process. There's a little bit of overlap when it comes to medical device approvals and the evidence you might need at the R&D phase. We focused on development, external validation of a model, and deployment of it. And so I'm not going to show you all of the details, as I say, it's going through the copyright office, but I'm giving you like the overview. We created different headings. So For example, these are all of the criteria that a developer may need to satisfy, or research and developer may need to satisfy for the development stage. These are the phases for external validation and for deployment. And so here under development, I circled one of them, data limitations and biases, what a developer may need to show as evidence. We created this page of information that we may seek from a researcher or a developer who's creating an AI system. So for example, looking at what sort of data has gone into training a model, whether they've considered matters of citizenship, residency, religion, ethnicity, age, race, gender, and other traits relevant to Qatar and the Arab region, because we're trying to tailor them a little bit, at least the information that we're trying to seek. So where we are now with this then is these are fully fledged guidelines. We've created a website, and the idea is that, this is the big question mark. The big question mark is, where does this fit in? Does it fit into an existing IRB process? Or should this be a separate expert committee under a ministry that sits and judges these applications for approval of their research that can perhaps get certified? Should it be internal to a ministry? Should it be external to a ministry? Should it just be simply we take this model and we apply it to the IRB within each institution? This is the big question now that I don't have the answer for, and that's going to involve bringing together all of these people that we've been talking to about creating the guidelines to now say, well, we've got them. How do they fit into the ecosystem in the most sensible way? So that's the next step, and that's going to take time, honestly, to figure out. And I've heard other events and talks that I've been to in the last year, this same consideration about where would guidelines fit into an IRB process. And we haven't got the answers, but we've got the guidelines, and we think this can be a model for other countries to follow. They're based on best practices. And so, as I said, we've also blueprinted the website, what it would look like. We created a scheme for those who may want to submit the evidence to a committee so it all links up. One other thing is just to consider about how this might fit into the landscape. Does one commercialize it? Do we create just a separate entity outside of the government that is formed of an expert committee that has got at least approval from some reputable institution that then gives, assesses these applications, certifies it, and the people who are submitting the application pay for it? Now, that model, when it comes, we can, Professor Oliver talked about different models of regulation, but one thing I'm keen to see is to have a scheme that is self-funded in a way. Because regulators and governments hate regulations that are going to cost money. And there are examples of that. Just to pull one completely out left of field, the lobbying regulator in the UK, this is another area of research of mine, they're self-funded. They charge for oversight. So you can be sufficient if you set up in the right way, self-sufficient. So then we turn to the next stage then, which is the medical device approvals process. And I was so happy that Sarah covered a lot of the things that are happening in the US, because then it makes this a lot much shorter and sweeter. It's interesting when one looks at Saudi Arabia, they have quite the architecture, the regulatory architecture of laws, of guidelines, of requirements. And there's a couple here, I looked at them all, and there's a couple here that are quite relevant to AI-based medical devices. One of them is the third on the list, the implementing regulation of the law of medical devices. That's the core law in this area. And then further down the list, in dated 29th of November 2022, is the guidance on artificial intelligence and machine learning technologies based medical devices, or the MDSG10, which is what I published on recently. And so what's interesting is, by and large, when we look at medical device regulations, AI-based medical device regulations, they're non-binding and they're recommendations, although they are followed. But Saudi Arabia seems to take a little bit more of a step than other regulators, because they refer a lot in their guidelines to the binding natures of the laws that underlie the guidance, which seems to indicate they're taking a bit of a stricter path And they're more likely to go down the sanctions path and imposing penalties for those that don't comply with the MDS G10. And from those I speak to, I just came yesterday in Qatar, we had the World Innovation Summit for Health there. It's this big conference every 2 years. And there were some developers from Saudi Arabia there. And I asked them how active the SFDA are, the Saudi FDA. And they said they're very active when it comes to compliance and checking whether developers are complying with these guidelines. So it seems the enforcement isn't a joke. So what is the purpose of the MDS? Well, it is to clarify the requirements for obtaining medical device marketing authorization to bring AI-based medical devices onto market in the Saudi Arabia market. It defines AI devices as those that diagnose, manage, predict diseases by analyzing medical data. And so the key question under the guidance is what the product developer, or as they call the developer, the manufacturer, intends the device to be used for. If it's intended that the device is to be used for investigation, detection, diagnosis, monitoring, treatment, management of any medical condition, disease, anatomy, or physiological process, then it's considered a medical device and the controls apply. And so what they'll do is they'll look at the product specifications. What is the information that's being submitted to determine whether the manufacturer has complied, or the developer, as they call them. Underlying that, and I'm not going to go into the weeds here, but I do in my article, is all of the criteria, classification criteria and control methods, the clinical evaluation criteria, risk management criteria, quality management system, change notifications, things we see in other medical device regulations. But there are some things that are quite interesting to see. So when it comes to the, I just want to see I'm not missing anything important on this, because sometimes I do skim over. So one of the things I found quite interesting is the harmonization. So in the guidelines, Saudi Arabia refers to the FDA in the US when they are discussing their guidelines. They refer to the South Korean ministry, and they refer to the IMDRF a lot, the Medical Device Regulators Forum. And what Saudi does that's distinct to other regulators, or what they did in the first instance that was distinct, was for these criteria, they were pulling in directly guidelines that others hadn't and just incorporated them straight into the MDS G10. So, for example, they brought in the guidelines from the World Health Organization on the ethical evaluation of AI, and they pulled them and put them into their guidelines. They beat the FDA in the US by bringing in certain ISO requirements before the US FDA did. So there's certainly some either alignment, coordination, or some healthy competition. They are part of the same forum, so obviously they have these discussions together, but I just couldn't find the full data on whether it's competition driving this or they're just trying to be innovative and being at the front. But it is interesting to see how these different pieces are coming together. What I would say, though, is that the MDS G10 is, to me, it looks like a patchwork of existing international best practices. As I mentioned, there is some congruence between the FDA and the SFDA. The binding nature of the MDS G10 is complex, but I do think it does have binding elements. And in a sense, I would put the SFDA at the front, one of the countries that is at the forefront of looking at this issue, and they're doing things that other regulators haven't done, which I found to be something was unexpected. And this would constitute then, if we're thinking about the larger matrix, the R&D processes which we had, which I think Qatar gives us an example of guidelines we may have in that space. Saudi Arabia gives us a good example of the second phase, the medical device phase, and approvals in that space. I'm not saying they're perfect. There's still a lot of work to do, but we're trying to put these pieces together in an evolving landscape. The UAE then is the clinical practice phase. And to me, they are the standout country to do this, and I haven't seen a country do this yet. Although I'm happy to I will stand corrected if there is, or if somebody beat the UAE to this. Having said that, I don't know whether the extent to which what the UAE have created is being implemented and regulated in practice. And that's an open question. I can't find data on that yet. What we have in Abu Dhabi and Dubai is two policies, as they call them. But then when you read them, they're not really policies in the sense that we might understand soft law, because the policies refer to hard law, and they refer to, if you don't part of the considerations of bringing your device to practice is you've got to comply with laws on medical liability. You've got to comply with all of these different requirements. And if you don't, we as the health authority can impose sanctions on you and penalize you. So it's not really a policy. It's more like a law when you read it. But I'll just briefly mention them because I've got a minute and a half left and then I'll stop. So the guidelines cover ethics. So they set out the ethical and regulatory requirements for AI solutions in healthcare, setting out that AI solutions for healthcare must be free of bias and they must benefit society in the UAE. They have provisions on safety and security so that AI solutions for healthcare that may directly impact people's lives in a significant way must be designed with the utmost care, and such solutions must be able to be overridden or their decisions reversed by designated users. They talk about the performance of AI tools and how they must be monitored in practice, and that a tool must go through repeated cycles of improvements and updates based on continuous feedback from the end users for accuracy, and that feedback must be sent to the health authorities. And so it goes on. This is the same in both Emirates here, where they set these out. Here, there's a principle, for example, of user assistance, that AI should assist users by giving them reasonable opportunities to make intelligent decisions using AI-generated probability-based suggestions. And it even considers the accountability applying to developers too. So I know I don't have time to go into these, but it's very interesting how they have considered this on the clinical side. And I just add that they've defined the clinical side very broadly. It's AI used in almost any clinical setting or health setting in the Emirates. So, but even when I read their requirements, it crosses over a little bit with what we have in medical device regulations and even the research guidelines that we had. So there are points of crossover and points of distinction. And so I guess that's what I wanted to say. I'll end on that. If we're not already connected on LinkedIn, feel free to connect and continue the conversation. So thank you so much.
Thank you, Barry.